Okay, I think we can get started at this point. We're a minute after the hour, and we don't want to waste any more time in getting to the important topics of the day. I have my colleagues, Jim Peterson and Sarah Willey, on the line. I'll give everyone a moment to introduce themselves.
Yes, good afternoon, everyone. This is Jim Peterson, and we're looking forward to hosting this webinar and answering the questions that we can.
Hi all, this is Sarah Willey. I'm looking forward to talking to you all more specifically about what this means for workplaces. And spoiler alert, I'll be talking more than about masks. We'll be talking about lots of things and what everyone should be doing today, if anything, and what the landscape is likely to look like going forward. So,
great. So we're going to kick off this webinar with a little introduction. I'm sure all of you who have joined this call at least have some idea of what went on in the past couple of days. On Friday, late afternoon, the Michigan Supreme Court answered the certified questions that had been sent to the Michigan Supreme Court from the Federal District Court here in the Western District of Michigan regarding Governor Whitmer's authority to issue executive orders related to COVID-19 and related to the constitutionality of the statutes that granted the governor authority to issue certain types of emergency orders. On Friday, the court's opinion was issued. The court held that that the executive orders issued by the governor in response to COVID-19 lack any basis under Michigan law after April 30th. And the court also indicated in its decision that its ruling leaves many avenues open for the governor and the legislature to work together to address the continuing challenges that we all face here in the state of Michigan and across the world and across the globe. We're going to talk first about the opinion, what it says, what it doesn't say, and even with that opinion in place, what sort of effect the opinion has on Michigan law as we know it today. To get going with that first topic, Jim, I'm interested in whether you could give us a little bit of a bigger summary than I just provided, but still a summary of the Michigan Supreme Court's opinion, what that opinion was, how it affected the Emergency Management Act of 1976 and the Emergency Powers of the Governor Act of 1945.
Sure. Thanks, Amy. And your summary was very good. I'll just give a little bit of background here. The way this case made its way to the Michigan Supreme Court was from, as Amy said, the federal court here in the Western District of Michigan, who certified 2 questions to the Michigan Supreme Court for answer. And basically those questions involve the issue of whether the governor had the authority under the Emergency Management Act of 1976 to issue executive orders related to COVID after April 30. And April 30 is the important date because that is when the Michigan legislature allowed the governor, extended the time for the governor to issue orders under the Emergency Management Act. The other statute at issue was the Emergency Powers of Governor Act of 1945, and unlike the Emergency Management Act, that statute did not have a time limit and did not address whether the legislature would be able to extend the state of emergency. And so what the Michigan Supreme Court did is answer those 2 questions from the federal court about the governor's authority. And what's significant is that the Michigan Supreme Court was unanimous. All 7 justices agreed that the governor did not have the authority under the Emergency Management Act to continue a state of emergency and issue executive orders after April 30, and then where there were some dissents was on the issue of the Emergency Powers of Governor Act. The majority, in a 4-3 decision, held that the Emergency Powers of Governor Act of 1945 was unconstitutional as violative of separation of powers principles and non-delegation principles. And the other thing I think that's important for listeners to know is that the Michigan Supreme Court was not taking aim at the governor in its decision. It was really on the 4-3 in particular decision was taking aim at the legislation itself and found the legislation was constitutionally defective. What was really never at issue in any of the Supreme Court arguments or briefing was the wisdom of what the governor was doing in terms of attempting to protect public health and safety.
Thank you, Jim. That was really helpful. One pressing question that's on the minds of many is, when does this opinion of the Supreme Court take effect? I think we're going to talk a little bit more about the opinion, but just the bottom line of when the opinion takes effect has become an issue over the course of the weekend. What is your thinking on when the opinion actually has precedential effect?
Sure. So two things, right? Because of the posture in which the court addressed these issues as certified questions, right? The Michigan Supreme Court is the supreme authority on what Michigan law is and what it allows. It answered those questions and found that the executive orders issued after April 30 that are related to COVID were without any basis under Michigan law. So my view is that means on May 1, they were without any basis under Michigan law. And as we sit here on October 5, they are without any basis under Michigan law. The Supreme Court has already sent its opinion to Judge Maloney in the Western District of Michigan. It sent it to Judge Maloney at the same time it sent it to everyone else who had entered appearances in that case. And so my view is that the opinion is effective immediately, and I don't believe that there could be any successful attempts to enforce the executive orders at this point or any point after the Supreme Court issued its decision. Now, interestingly, just literally less than an hour before this webinar in the Michigan Supreme Court, the governor and the director of the Department of Health and Human Services filed a motion seeking to delay any precedential impact of this decision for a period of 28 days. So they filed that motion. It has not yet been decided. So we don't know what the Michigan Supreme Court will do with that. But I think the governor was incorrect to say that her executive orders remain in place for 21 days. I don't believe that is true in light of the Supreme Court's decision.
Jim, this is Sarah, does Judge Maloney have to take any action to now invalidate the executive orders, or was the Supreme Court decision itself enough to accomplish that?
Right. I would anticipate that Judge Maloney will take some action in that underlying lawsuit regarding the two state law questions that were presented to him, but I do not believe it is necessary for him to give some legal effect to the Michigan Supreme Court decision. The Michigan Supreme Court has spoken. These orders were and are without any legal basis. But I would expect that Judge Maloney will address that in due course in the federal lawsuit as well.
Yeah, and this is Amy. I'll add too that that the the case out of which sprung those certified questions, which is Midwest Institute of Health or Grand Health versus Whitmer, that isn't the only pending case in which those certified, those questions, those answers to the certified questions will control the outcome of the case, including the legislature's case. The legislature had a parallel case moving its way up through the state courts on these same issues, and that case is still pending before the Michigan Supreme Court. But presumably, there will be a way to get an answer to that appeal relatively shortly, given that the Supreme Court has essentially ruled on the issues in the legislature's case now too. So it's not only Judge Maloney who has the ability to enter some sort of a order to taking effect in a case based on those answers. Other cases, including the legislature's case, will probably have similar opportunities for the Supreme Court's answers to compel the result in those cases.
Yes, correct.
Jim, while we're on the topic, oh, go ahead.
No, I'm sorry, go ahead.
I was only going to say, what have we heard from the Attorney General's office over the weekend about the enforceability of the governor's executive orders?
Right, so a couple things there as well. The Attorney General's office has said that it will not take any enforcement action regarding the executive orders related to COVID-19, but that independent units of, I guess, local police, sheriff's department can take enforcement action, that her decision as the Attorney General for the state was not binding on those independent organizations. That said, I would not expect any local units of law enforcement to be enforcing these executive orders, and I would not expect any of those enforcement efforts to be successful in light of what the Michigan Supreme Court has said.
Right, so setting aside local enforcement of the governor's orders, we do have other orders that are effective and have been for quite some time, issued by the Director of the Department of Health and Human Services. And we'll be talking about those orders during this webinar, but just at a high level, Jim, did the Michigan Supreme Court's opinion have any effect on those separate orders of administrative agencies?
It did not, right? So there have been orders by the Director of the Department of Health and Human Services that have been in place since, I believe, April 2, and they've been modified a few times. The most recent one that I think is probably broadest and of most interest to listeners would be the emergency order that the Director issued at the end of July. And in that order, the Director adopted the restrictions that were existing at the time in Executive Order 153, which governs masks, Executive Order 160, which was the amended Safe Start Order, which had restrictions on gatherings and what businesses were required to do in terms of remote work, things of that nature, and then also Executive Order 161, which is the Safeguards to Protect Michigan Workers. And so those three orders, the restrictions of them, were incorporated into the Director's order, and those are still enforceable. The Supreme Court's decision did not do anything to invalidate those, even though it invalidated the orders on which those restrictions were based.
And Jim, could you talk a little bit about what the Director or the Department of Health and Human Services, what mechanisms it has at its disposal for enforcement of its own orders?
Sure. So under the Public Health Code, the Director has pretty broad authority in the course of an epidemic to by emergency order, prohibit the gathering of people for any purpose, and to establish procedures to be followed during the epidemic to ensure continuation of essential public health services and enforcement of health laws. And what the director did when he adopted the emergency order was, even though the public health code would allow violations to be prosecuted as criminal misdemeanors, Director Gordon said that he was going to treat violations as punishable by a civil fine of up to $1,000. And so even though I believe the director would have the authority to deputize law enforcement and to enforce the orders through the penalty of criminal prosecution, under the terms of the order, he has elected to use civil fines of up to $1,000 in order to enforce them.
Jim and Amy, can you just for a minute, can you speak to the breadth of the director's authority and ability to issue these emergency public health orders?
Sure. So I'll start, and Amy, please jump in and let me know if you agree or not. Right. So up till now, the director has grounded his authority under the Michigan Public Health Code and dealing with an epidemic. And so I don't think there's much question that there's an epidemic. And so I think that the question, and this will likely have a spotlight shined on it to the extent there are disputes later, is has the director appropriately cabined his emergency order to procedures that ensure continuation of essential public health services? So I don't believe it's the case that the director can simply take every single thing that the governor has done or tried to do in the executive orders and say, I'm going to implement those same procedures under my authority under the Public Health Code. The director's authority is not as broad as what the governor claimed under the Emergency Management Act or the Emergency Powers of Governor Act.
Yep, I agree with that. I think, you know, a lot of attention will now be turning to the sections of the Public Health Code that the director may lawfully operate under when he issues emergency orders. And so we'll be paying particular attention to those statutory boundaries on the director's power. It is interesting to note simply that the director has not been issuing an order every single time the governor issued an executive order since, you know, the beginning of March of 2020. It has been a more circumscribed process than that, and the director has identified specific executive orders as in keeping with his statutory authority. But as we'll talk about later in this presentation, we are expecting to see very soon some additional orders probably coming out of the director's statutory authority under the Public Health Code. So we'll be paying particular attention to that. One other thing to note is that it's not simply the state that can take these steps during an epidemic. There is local authority for a local health officer and also authority that a county could arguably take in executing on its own orders. Have we seen any of those coming up over the course of the weekend, Jim?
So yes, I mean, the last I looked, there were 2 countywide public health orders, Oakland County and Ingham County, that were quite broad, and we would expect to see more. You know, my personal preference would be to have a more uniform approach, right? And so to have the director of the Department of Health and Human Services issue an order that applies statewide at least in some respects, would be more helpful. I'm not suggesting that it really, there should be a statewide order that impacts everything, because as we know, different areas of the state are at different, I guess, face different challenges based on the spread of the disease.
Agreed.
Sarah, do you have any questions for us on the scope of the order, or when it takes effect, or is there anything that we haven't clarified well enough yet before we move into the discussion of what we, would guide our businesses on this call to think about as they set forth on these?
Yeah. I think one question that I'm seeing come up a few times is this. So many of these executive orders contained restrictions on businesses to operate or imposed requirements, right, that involve masks and temperature checks and daily screenings, et cetera. But also many of them loosened requirements that would have otherwise been in place but for COVID. So one example is public meetings have been allowed to be held virtually rather than in person. And so I'm getting a lot of questions also regarding that latter category, right? What if my organization relied upon an executive order that loosened restrictions during this time frame? What does that mean for me now if that executive order goes away? Does that mean I'm going to be in trouble because I relied upon it at the time?
Yeah, that's a great question, and that's one that many lawyers across the state are dealing with, and I believe the state bar is dealing with that issue as well. You're exactly right. I mean, because of a loosening of certain restrictions, for example, there was remote notarization that was allowed, and so I know that the probate and estate planning section of the state bar is addressing that issue and attempting to come to some consensus on what happens with my estate planning documents that were signed remotely rather than in person. And I would expect them to come up with an answer to that, and maybe there would be legislation that actually put that in place so we don't have to undo everything or redo everything that was done before. Same thing with the question for open meetings, right? We're still, I think, unsure about what the implications of this are going to be for the requirement to hold open meetings in person, but we expect that to be sorted out pretty quickly.
Right. In other words, it's not clear yet what the fix might be, but our best guess is that we're going to have some sort of a solution to that dilemma.
Right. Yeah, we're so early after the decision that there isn't a lot of clarity yet. There is about some things, right? But we would expect that there are going to be solutions that are clear in the coming days, right? For example, the executive orders or the restrictions that were adopted by the director, right, rest in part upon executive orders that have not only been invalidated, but also were superseded by later orders. And so, I think the thing that will be sorted out in the coming days, and hopefully quickly, are what are the applicable restrictions. Right now, by its terms, the director's order incorporated the restrictions in Executive Orders 153, 160, and 161, and two of those have been, I guess, supplemented with different restrictions, which have not been expressly adopted by the director. Right.
And one other question for the two of you, and then I'll jump in and talk more about workplaces, is the director's current emergency order that's in place, that July 30th order, basically incorporates the governor's executive orders, right? And so if those executive orders have now been invalidated, do we think still that director's emergency order carries weight? Is it enforceable?
I believe it is enforceable, in part because the director didn't incorporate the executive orders in those terms. What he said was, I'm incorporating the restrictions in the executive orders. And so that slight difference in language, I think, makes it so that they are enforceable because he simply incorporated the restrictions in the orders. If he had said, I'm adopting these orders as my own, I think there would be, it would call into more doubt whether the restrictions could be enforced. And I know that's in some ways it's semantics, but as we know as lawyers, that's often what makes the difference.
Right. Thanks, Jim.
And I'll add that I think whatever lack of clarity there may be about that particular question, Sarah, it's probably going to become moot pretty quickly because we do expect the director to issue a cleaned up order soon enough here that incorporates whatever policies and procedures and restrictions the director thinks were appropriate under his own statutory authority, potentially without the cross-referencing to the executive orders themselves, but at the very least, continuing that word choice that Jim mentioned in relation to the orders that were the ones that were in effect on Friday, as opposed to these superseded orders.
Yep, that makes sense. Okay, well, let me jump in then and talk a little bit more specifically about what this decision means for our workplaces. Thanks to Jim and Amy so much, not only for their important insight today, but for their important work on that case as well. So thanks to both of you. Well, as might be expected, over the weekend, we had a flurry of excitement and news, right? As has been the case throughout the pandemic, this decision came down on Friday. I think it was maybe just after 5 o'clock or so. Those of us who have been working in law firms and other places have become accustomed to significant changes occurring on Fridays after 5 p.m. So that was nothing new. So the decision was released on Friday. Shortly thereafter, our governor issued this statement, which was a bit confusing because it had that reference to the 21-day grace period. And to be clear, for those who missed it at the beginning, we don't fully understand where the governor's office got that 21-day grace period. Our best guess is she was relying upon some court rules that we don't believe apply. She does seem to have backed off from that position now in the meantime. So we don't think there's an argument at all that the Michigan Supreme Court's decision is not effective for 21 days. But more importantly, she made clear from the beginning that notwithstanding the Supreme Court's decision, she would use other sources of authority to sort of create and enforce the restrictions that she believes are necessary right now during the pandemic. And that's been the case since the beginning. One thing that Jim and Amy both said, but I do want to reiterate because I think it's really important to understand this piece. The Michigan Supreme Court did not say that COVID-19 is no longer a public health emergency. The Michigan Supreme Court did not say that we are not actually living in a pandemic. And quite frankly, the Michigan Supreme Court did not say that anything Governor Whitmer had done was unreasonable. Okay, so understand that. There's been a lot of sort of misinformation and misunderstanding about what the court said. The court said that the statute, the 1945 law that our governor had been relying upon, was unconstitutional, and that's all. Nobody's passed any judgment yet on the restrictions that have been in place via her executive orders. So we had her statement on Friday, and then over the weekend, the legislature spoke via their majority leader, essentially saying that the legislature does not have an intention of now reinforcing the requirements that had been in her executive orders through legislation. And in particular, they said that they do not have an intention of legislating on the mask requirement. As probably almost all of you know and recognize well, the requirement of masks is a hot topic, a touchstone for many, many, many people, and quite frankly was by far the most popular question I got over the weekend. Do we still wear masks? Do we not still wear masks? Can my business still require masks? Must my business still require masks? Do my employees have to wear them? Do I have to wear them at the soccer game, et cetera? Okay. Then yesterday, our governor doubled down again, making clear that she will continue to use every tool she has at her disposal to impose restrictions. Okay, so the bottom line here, guys, is there's no doubt that our governor is going to be using the things within her control to continue to impact our workplaces and what we have to do as businesses. And we know that's going to be done through the Department of Health orders that are in existence today. We know that'll be done through additional Department of Health orders. We know that will occur through MIOSHA enforcement. We're going to talk about that for a little bit. And we also know that even beyond our governor, we are likely to see requirements on the local county health level too. In other words, we are going to be living in a time much like we were living in back in April, before we had all of these executive orders in place. We were following what our departments of health were telling us to do. We were thinking about MIOSHA and OHSA requirements, and we were following CDC guidance. Okay, so it's going to look a lot more like that patchwork rather than us complying with these executive orders. As Jim mentioned, we at least have 2 Michigan counties now that have required masks. I anticipate there will be many more. So we are going to have to follow things on a local level as well as a statewide level too. Just a helpful hint for all of you, you can go on to the Michigan Department of Health and Human Services website and sign up for news updates, subscribe to their news service. That will notify you, hopefully, but I think it will notify you whenever they issue a new order of which you should be aware, okay? Many local health departments have that same service, so I recommend you all do that now. You can also do the same thing for MIOSHA, okay? So start getting into the rhythm of having to pay attention really on a daily basis, pay attention to what's happening with regard to requirements in your local communities. Of course, Miller-Johnson is going to keep up on all of those developments too and be communicating them, but it's best for you to be following them as well, okay? So when we talk about executive orders that are no longer in effect, here are the most significant ones that impact workplaces, okay? EO 76, expanded unemployment eligibility, Now that all of a sudden is gone, right? There was that executive order that says individuals who can't work for COVID-related reasons can get benefits, and also that it had beneficial cost-sharing implications for reimbursing employers, okay? EO 128 had clarifying workers' comp eligibility information. EO 153 was that executive order that mandated all of us as individuals to wear masks in enclosed public spaces with that $1,000 penalty. And then we've got several others. EO 164 mandated masks at child care centers and camps. 172, guys, it was that executive order that started as Executive Order 36. That's the order that tells all individuals that if they have tested positive for COVID, if they have one of the primary symptoms of COVID, or if they have come in close contact with a person who has either one of those, that mandates individual quarantine and also tells employers that they can't retaliate against employees for following those. That EO 172 is in flux right now. That has not been captured in a Department of Health order or in any other enforceable order right now in Michigan, although I would anticipate that is high on the governor's list to try to figure out how to enforce through another source. So be watching for that. And then the rest of the executive orders that apply to employers, EO 183 is that Safe Start order. EO 184 is the order that has all of those workplace requirements, right? There's a long list that apply to all businesses with in-person operations, and then it has specific requirements by industry. EO 190, requirements for food selling establishments and pharmacies. That, by the way, has been folded into EO 184. And then finally, Executive Order 191 had specific requirements for residents and staff of long-term care facilities. And we're going to be talking more specifically about EO 183 and 184 and what that means today. But I wanted all of you to have that list in front of you to understand the impact of the Michigan Supreme Court decision and be thinking about what's in place still for your business, okay? Now, as I explain where we sit with the current landscape, I want you all to remember there's really two questions that you guys are going to be thinking about and answering in the upcoming days. And the first one is, what does my business have to do? What orders remain in place that I have to follow right now, okay? But the second question is, what does my business want to do? And you will likely have different answers to that question. A great example of that is if there is an argument that schools no longer have to require masks in K through 5, right? That was a requirement that was supposed to become effective today. There is an argument that you don't have to require those masks of those young students, okay? But not every school is going to make that same choice. Some schools are going to choose to enforce that requirement anyway, and they have every right to do that, okay? Again, the Michigan Supreme Court did not say that it was unlawful to impose restrictions to flatten the curve or to stop the spread of COVID. It simply said that these existing executive orders relied on a statute that was unconstitutional. So schools could voluntarily decide we are going to require our students K through 5 to wear masks because we think that's necessary in order to keep operating our school safely, okay? Just a spoiler alert, my practical advice for all of you today, and I hope you come away with this understanding, is that if there are specific requirements that have really been a burden to your business in particular, and you're delighting in the potential opportunity to stop doing those things, right? Maybe it's temperature checks because you're a manufacturing facility. You need to review with legal counsel the risk in doing that. What does it look like for you if you stop doing those things right now today because of this decision? Otherwise, my practical advice is going to be stay the course in the short term. Stay the course until we see what Department of Health orders are coming next and what they look like. Otherwise, it's likely that you're going to change what your business is doing right now because you're speculating as to what's going to happen in the future, and then you're going to have to circle back and make more changes because you're not going to guess exactly right. Okay. So let's talk about what Department of Health orders are in place now that impact workplaces. Okay, so I picked out only the ones that I think have the greatest impact to workplaces. The first and obvious one is the one that Jim and Amy talked about. That was an order that was issued on July 30th, and that incorporates the executive orders that were in existence then as of July 30th, and that was EO 153. That's the one that tells all of us that if we that we have to wear masks in any enclosed public space. EO 160, which is the Safe Start Plan, that's now EO 183, and EO 161, that's now 184. So this is kind of a fun game, right? So we have an emergency order that was issued 2 months ago, over 2 months ago, that incorporates specifically two executive orders that have now been rescinded and replaced with other executive orders, okay? And so what does that all mean? We don't know exactly what that all means, except that we do have a Department of Health order that definitely incorporates the requirements of then EO 160 and 161. Whether it also incorporates 183 and 184, we're not sure. But to Amy's point, it probably is not worth spending much time thinking about that because we think the Department of Health is going to fix that problem in the very short term anyway. And in a minute, I am going to explain to you and remind you what EO 160 and 161 said and the difference between 183 and 184, okay? Other Department of Health orders that are in place now, there was one on August 19th that mandated testing of prison staff. There was one on August 14th that mandated testing, preventative measures, and safe housing for agricultural workers. And then there was one on June 15th that mandated testing of certain nursing home staff, okay? All of those things, all of these orders, these Department of Health orders are still in place. This Michigan Supreme Court decision did nothing to invalidate any of those. Okay, and as a reminder, the statutory authority that the Director of Health has is to issue these emergency orders in the event of something like a pandemic that prohibit the gathering of people for any purpose and establish other procedures to be followed to ensure the continuation of essential public health services. In other words, to avoid a major outbreak that would jeopardize our public health services, sort of like what we saw in March and April in big cities like New York, Detroit, et cetera, okay? Things that flatten the curve. So as you know, we have this Department of Health emergency order that specifically incorporated then existing Executive Order 161. Okay. Executive Order 161 was signed on July 29th. So we have to sort of take ourselves back to remembering what times were like on July 29th. What was required then? Well, I can tell you both EO 161 and what exists now that replaced it, 181, both require that COVID preparedness plan that hopefully you all have. It requires us to have COVID workplace supervisors on site. It requires training, daily health screening, social distancing. It requires employers to provide face coverings to all employees. It requires employers to mandate employees wear face coverings when they can't maintain 6 feet distance and when they're in shared common spaces, okay? So all of these things arguably are currently in this Department of Health emergency order that exists today. EO 161 also required, and EO 184 continues to require the basic workplace COVID prevention measures that most workplaces are following, the cleaning and disinfecting, the positive test protocol. You got to follow CDC guidelines if somebody has a positive test. There are notice requirements, et cetera, okay? Now, EO 161 not only had all of these requirements for any business with in-person operations, but then we have the industry-specific requirements for all the things listed in this last bullet point of my slide. I am not going to go through them all because otherwise we would be here all afternoon. But hopefully all of you guys know what I mean. If you're a manufacturing facility, there are additional layers of requirements like temperature checks, et cetera. Same for sports and exercise facilities, et cetera, okay? All of those were in Executive Order 161 and also in 184. There are very few things that Executive Order 161 did not do, okay, that we understand to be happening now. And quite frankly, on balance, this is not helpful. Because EO 161 did not yet allow for non-essential visitors, okay? It didn't yet require masks when exercising in fitness facilities. So that's an interesting conundrum. It's not clear right now whether exercise facilities, fitness facilities have to require its members to wear masks or not. Okay, that's a gray area. I'm guessing the Department of Health is going to fill that in with an answer soon, okay, et cetera. So let's talk a minute about what Executive Order 160 says. So remember, we've got this Department of Health emergency order that is enforceable now that incorporates all of the requirements of Executive Order 160, okay? That also was signed on July 29, okay? And so if we're following Executive Order 160, if we go back in time to July 29, that means, guess what? Gyms and fitness centers are still closed, except in regions 6 and 8. It means gatherings are more limited than they are now because recently in Executive Order 183, our governor increased the numbers that were allowed in those indoor and outdoor gatherings, and Executive Order had no mention whatsoever of organized sports or pools. So if we're operating simply by Executive Order 160, those are areas in which we don't have any clarity right now, okay? They both require that any work that is capable of being performed remotely must be, unless you're in region 6 or 8. They both require social distancing for anyone leaving home, and they both require compliance with EO 153, which is that mask executive order. Okay, so that's what's arguably in place now. Okay, in place now, again, is Executive Order 153, 160, 161. What else do we think is coming? Well, as we've said several times, we think the Department of Health is going to be issuing more orders shortly. Number one, to clean up that July 30th order and also to answer questions regarding Executive Order 172, questions about schools and sports, etc. Probably we're going to see more litigation than over the level of authority that the Department of Health has to be doing that. Okay. Just to mention about schools, I know we've got lots of questions about schools and we've got lots of attendees who are schools. We are holding a webinar, I believe tomorrow, specifically for schools and to answer lots more questions in detail that apply to schools. So please sign up for that if you are attending and you represent a school, okay? I think we're going to see more potential legislation. The Republican legislature has already sent the message that they are more than willing to pass legislation addressing unemployment benefits. So it's likely that hole will be filled through the legislative process soon. And they may also pass legislation in some of these other areas too. And then, of course, we're going to see these local county health orders adding another layer potentially of requirements. And we were following, at the beginning of all of this, those local county health orders were very important and we were following them. It's just that in these last several months, the governor's executive orders became much broader, so those local orders just didn't have much import anymore. Well, obviously now they're back in the spotlight. I think we'll see those orders not only requiring masks, but if we don't otherwise see the Department of Health doing that, mandating workplaces conduct certain screening protocol and positive test protocol. And the reason I say that is because that's what the orders did back in March, April, May, and June, et cetera. Okay.
Hey, Sarah, before you move on to MIOSHA, can I just ask you a couple questions that I've seen come up from listeners? And I'm interested in your take and then also Amy's take. So if the restrictions in Executive Order 153, 160, and 161 are still enforceable under the department's order, but those restrictions have been modified by later orders, as you've observed, what's your advice to businesses about what they should do? Should they comply with the ones that are expressly referenced? Should they comply with the ones that the governor has indicated she would like to remain in place? And what are the consequences of that decision?
You know, to be honest, Jim, from a practical workplace standpoint, there's not much difference between, for example, 161 and 184. Okay, so with regard to the day-to-day things that workplaces with in-person operations are supposed to be doing, they're the same. So I don't know that I would spend a lot of time fretting over the difference between, for example, 161 and 184. Now, if there's a unique wrinkle and something did change, I'd probably want to talk to that business more specifically about that.
Great, thank you. Amy, is your answer the same?
Yeah, it really is the same. And then I would highlight what I think we've been saying for now over half a year, which is that these are wherever the restrictions find themselves in the governor's own orders or in the department's orders, they are complex. They do take time to read and interpret and digest. And what I think the law really asks of our businesses and our individuals who are seeking to comply is a good faith effort in that. And so there are difficult decisions that have to be made. And on those difficult decisions or wrinkles, as Sarah was mentioning, you can call us or call your legal counsel and get guidance. But at the from the high level, what I think we often tell our clients is do your best to comply, and let's do that in good faith. And that can be a struggle, that alone, but I think the good faith efforts of our clients pay off when questions do arise.
Great, thank you.
And I think that that's a good segue, Amy, so thank you for that, into a reminder about MIOSHA. We've got so many layers here that workplaces and businesses are thinking about. And one additional one is MIOSHA. I'm not going to talk in depth about MIOSHA today because we just have so many things to cover, but we are having a MIOSHA webinar, and I believe that one is scheduled for Wednesday to talk more specifically about that, right? So notwithstanding the Supreme Court's decision, and also notwithstanding what the Department of Health emergency orders have done, we also do know for certain that all employers, anybody with employees, has a general duty under OHSA and MIOSHA to provide a workplace free from known hazards, okay? That requirement is also still in place, okay? And that's been something that we've talked about since the beginning of COVID. And quite frankly, I feel a little bit like we've come full circle, because when we first started talking about what COVID meant for employers, we were talking a lot about MIOSHA and OHSA requirements. And in fact, MIOSHA and OHSA were requiring this thing called a workplace, a COVID preparedness plan for workplaces. Even before our governor required it, they were requiring it, okay? So those considerations absolutely still exist. And in the background here, in the last several months, MIOSHA has developed several industry-specific guidelines. And in doing that, they've relied heavily on what Governor Whitmer's executive orders have said, okay? So we also have MIOSHA out there telling specific industries what they should be doing from a safety standpoint, and much of that does line up with what was required under these executive orders as well, okay? And we also have OHSA COVID control and prevention guidance too. From a workplace safety standpoint, I mean, a very simple way to be thinking about this is that we should be employing reasonable measures to, number one, stop people from coming to work if they have COVID, right? So what safety measures can we put in place to make sure that nobody's showing up if they have a high fever, have difficulty breathing, have tested positive for COVID, et cetera, okay? And then secondarily, what reasonable measures do we have so that if we have an employee or another person in our workplace who does have COVID, what have we done to try to make sure that they don't spread that to others? Okay, and it's really both of those things at the same time. And when you think about trying to accomplish both of those objectives, you're going to go back to many of the things that we were doing, have been doing, and still are doing under Executive Order 161, which is now 184, right? Those daily health questionnaires, the separation of employees to the extent we can, the plexiglass barriers in grocery stores and things like that, okay? And so a lot of those things we're going to probably be doing because we should be doing them from a safety standpoint anyway, as long as we're living in this global pandemic. All right, finally, so I'm sorry to make you wait to have me speak more specifically about masks. I've sort of been alluding to it. throughout this presentation, but I do think masks are a very hot topic right now. And the first thing I want to say is I was a little maybe surprised and dismayed at the level of misinformation and bad information on social media and on the internet over the weekend about the Michigan Supreme Court decision. Okay, let me state this as clearly as I can. The Michigan Supreme Court did not say that people can't be required to wear masks. Okay, they did not say that. They didn't say that people should wear masks. They didn't say that people shouldn't wear masks. They didn't say the global pandemic is over and everyone's free, unfortunately. I wish that were the case, okay? But there is information out there that claims that businesses can't require their customers or employees to wear masks anymore. And so you are going to get pushback from your employees. If you're a public-facing business, you're going to get pushback from customers because this is what they now believe. That is simply not true. Nothing about the decision said that. And in fact, as you've heard me explain today, there is a public health order that is still in effect today that does continue to mandate masks in any shared public space. And it also mandates employers to require their employees to wear masks if they can't maintain a 6-foot distance. So nothing has changed arguably in that regard because we have that Department of Health order in place, okay? So setting those aside, businesses can also choose to require masks if you wish to do so. So even if those things go away, right, even if we don't have an order in place, we don't have a county health order in place, or even if the Department of Health retracts its order, okay, just imagine that, your business could, if you chose, still require your employees and customers and clients and vendors to wear masks if you think it's necessary to do so for the purposes of basic health and safety. Okay, so with that is the end of my slide. I do see one question that I just wanted to mention right now, and that's, I've seen a couple of questions that reference the federal Families First Coronavirus Response Act, and in particular, emergency paid sick leave and emergency FMLA leave. That's a federal law, and the Michigan Supreme Court decision did not impact that in any way. So that remains, nothing has changed in regard to any part of the FFCRA. Are there other questions, Jim, that you think we need to address today?
Sure. So just one structural question that I've seen is, does the legislature have to do anything to put its stamp of approval on the director of the Department of Health and Human Services order or any subsequent orders issued by the director?
No. No. The legislature is not a check on the director's emergency orders. Although I would say if the legislature feels strongly that they don't like what the director is doing, they could pass legislation that would say otherwise, right? So they could pass legislation that from a statutory standpoint might have different requirements or restrictions.
Great, thank you.
The legislature could also modify the public health code. That is statute. That's the legislature's role. And if it felt that the director's power were too great, that is in the hands of the legislature ultimately.
Excellent point.
Yeah,
I also just thought I should echo too that you know, we included a screenshot to Senator Shirkey's statement from over the weekend, and just to emphasize once again a point that Sarah was hitting home during her portion of this presentation. Even Senator Shirkey noted that he encouraged everyone to follow the policies that individual businesses or schools or organizations might establish. So just because the Michigan Supreme Court ruled unconstitutional a statute that the governor has been using for many months now to issue her executive orders does not foreclose the possibility of individual businesses or schools or school districts from putting into place their own restrictions. And, you know, as private businesses, you may do that within the bounds of, you know, the non-discrimination laws of the federal and state laws of that kind.
Yes, good point.
All right. Well, I am confident that we are going to be talking in many, many webinars in the coming days to update everyone as things continue to evolve. And I want to encourage you all, Miller Johnson still, well, throughout the pandemic has put out an update every day as to webinars that have been held, developments, etc. So continue to follow those. Those are a great source. On our webpage, for those who haven't become familiar with it yet, we've got a COVID-19 page that includes all of our webinar recordings. And we also have a workplace COVID-19 resource center with lots and lots and lots of resources and documents to help you follow and comply with the evolving requirements. And we keep all of those up to date as things change and the ground continues to shift underneath us. So with that, I think we can sign off for now and talk to you all in the near future.
Great. Thank you all for joining.
Yes, thank you all.
Thanks all.